Hello, my name is Chris and welcome to our When Land Meets the Sea podcast, a coastal mini-series by David Jones Bold. On this podcast, Richard and Lizzie take a road trip around the coast of England and Wales and visit some of the most significant cases and legal issues relevant to the coast. UK coastal towns are some of the best places in the world to be, but they also face major challenges, faring disproportionately worse than inland towns and cities for health, education, socioeconomics, crime, and more. Through this group, we are working to change that. For example, we recently worked with the government to get coastal communities added to the list of mayor competencies under the English Devolution and Community Empowerment Act 2026. We've also developed a framework for coastal placemaking and stewardship, which you can download for free at www.djblaw.co.uk/blue-horizons. Enjoy the podcast.
Hello, Richard.
Hello, Lizzie. What have you been doing since we've last talked?
Not much. Just downloading podcasts, moving on to the next one. We're like a production line for podcasts now. So this is a different one. It's the first in a new series that we're pulling together around cases and law affecting coastal communities around the UK. So we're taking a bit of a tour around the English and Welsh coastline. So we're starting in Wales with two cases that talk about the ownership of Foreshore. And we can go into a little bit more about those cases in a minute. But do you want to start by telling us what Foreshore is defined as and what do we mean by it?
Yeah, it's the land, if you like, between the high and low water mark for the tide, wet beach, if you like. Strange definition, but it's between the mean points between the spring tide and the neap tide, Lizzie.
Yep. Spring
tide being the high tide, corresponding with the second and fourth quarters of the moon, and the first and third being the neap tide. But something like that, and who owns it? There was a case in 1854, Attorney General and Chambers said that the presumption is that the Crown owns the foreshore, but it is very much a rebuttable presumption, but a lot of foreshore is owned by the Crown. Most people can show otherwise. And there was also a case called Blundell and Catterall back in 1821 that basically said that public at large, we might come back to this a bit later on in other podcasts, but the public at large doesn't have an automatic right, a customary right in England and Wales, as opposed to Scotland, to use the foreshore. So that's the background to it. And there's a couple of cases about that sort of, well, if you like, proving or trying to prove otherwise.
Yeah, so should we go on to talk about these two cases, which both involve the same person, Mr. Mark Andrew Roberts, as I said earlier, both in Wales and from sort of the early 2000s, 2007 and 2008. The cases are Crown Estate and Roberts and Swangrove Estates. So, Richard, tell us the background to these.
Yeah, Mr. Roberts, he buys up lords of the manor and the likes. He's been involved in quite a few cases over the years. He actually is linked to me on LinkedIn, Lizzie, but who isn't? But anyway, the background is this. He bought up the Lord Marcher and Bishopric of St. David's in Pembrokeshire and basically tried to claim manorial rights to the foreshore and the seabed around Milford Haven, which is obviously a major port. And what he was objecting to, he put down a caution against first registration. If anybody wanted to go through a disposition that needed to be registered, the land registry would notify them, and then they could argue the case, and the land registry make a decision. And what happened is it was the Crown Estate Commissioners, as they do around the country, they basically gave licenses to the Pembrokeshire, this back in 2002, to Pembrokeshire County Council and also the Pembrokeshire Coast National Park. And the idea being that they would have licenses to do things like, if the Crown owns the bed and the riverbed and the likes and the foreshore, they can give licenses to people to put up wind turbines on the land or dredging for sand and this kind of thing. And they needed to, so they were given these leases to have said licenses before they were given these leases, which needed to be registered, and the land registry didn't know what to do about it. So they basically sent it off to court for a decision. And that's what the Crown Estate Commission is all about. He tried to argue various things were his. The rights to, basically fishing rights was one of them. I can basically grant licenses and not the Crown to fish on the land and so on. Estray was another one, which, do you know what that is, Lizzie?
I don't. Please educate me.
It's the right to own stray animals, stray domestic animals, tame animals that appear on the land and have been lost or abandoned. And now we've found something out. Wharfing, how about wharfing?
No.
Clue is in the title. Wharf.
Something to do with the wharf, yeah.
Yeah, it's the right to get money, basically, from people tying at up at your wharf. And moiety of wreck, have a go at that one.
This is going to be an education, this series, I can already tell.
You've got your English literature.
It's not helping me here.
First-class honours degree.
Neither's my A-level geography.
But moiety is the right to a half of the value of a shipwreck.
There we go.
There you are. And they was claiming all those kind of things, and a few others besides quick rents as well. I wouldn't argue with that. One of the issues involved was that he was trying to argue that, basically, that Pembrokeshire used to be one of the marches, not like the rest of them on the English-Wales border, the English-Welsh marches, but therefore it was the marcher lords who used to have sort of right conferred upon them by the Crown to hold the land and or to sort of administer the land. The marchers disappeared with the Act of Union in the era of Henry VIII, when England and Wales legal systems, amongst other things, became unified in 1535, Act of Union, then 1542. And then things like quick rents were finally abolished in 1660 in the 10 Years Abolition Act, but he tried to argue none of this applied to Pembrokeshire for various historic reasons. And so he could still claim these rights and produced or tried to produce various evidence of ancient rights, ancient customary rights and the likes. But at the end of the day, the court decided, with one exception, he hadn't produced sufficient evidence, the exception being moiety of wreck, which is
half of something.
Half of the value of a shipwreck. So he succeeded in that, but not the rest of it. And then shall we go along the Welsh coast?
Yes, let's go.
Right to the southeastern part of Wales, by the first Severn Bridge, which, if you know the area, the old Severn Bridge, he bought up various lords of the manor there, including the lords of the manor of Trelech, which was the major one in relation to the case. This is Robertson Swangrove Estates. And he was basically trying to argue that the foreshore and the riverbed in those parts was his as well. And the Crown and Swangrove Estates had been basically dredging on the land. They had granted licenses. People had been openly dredging, the granted licenses for people to dredge sand in the River Severn up to the midway point, the deepest point in the river on the Welsh side, around Methurn and Caerleon on Usk, if you know that place, and Major.
Mm-hmm.
But as I say, it involved three different individuals he was trying to stop. And they claim Swangrove Estates, a property management company who managed the Duke of Beaufort's estate. The Duke of Beaufort being based at Badminton in Gloucestershire. And rather than try and claim, find documentation going back to medieval times, they decided the easiest way to actually defend the claims would be to claim adverse possession. And we've openly been dredging. They talked about a case, nothing to do with the coast. It was all in Berkshire. Pye and Graham, the House of Lords case in 2003, which basically said you don't have to oust people from the land to claim adverse possession. They might have just discontinued possession, and it's a question of fact, really. You can have factual possession, the intention to possess the land, And for pre-2003 claims, when it was all changed to a registered land at least, on October the 13th that year, you have to show 12 years of factual possession, intention to possess, no right to be on the land. And they could do this by the open granting of licenses and dredging activities for many a year. And so they were able to claim adverse possession. It also confirmed quite significantly, because usually the Crown is the one that suffers from adverse possession. And on registered land or pre-2003 claims, you have to show against if it's Crown land, Foreshore, you have to show 60 years adverse possession, and for that matter in registered land as well, post-2003. But they said that the Crown can also claim adverse possession against you. So Swangrove and the Crown successfully claimed adverse possession of the riverbed, the River Severn. There was another person who owned a little bit of land there, or rights to a little bit of land there, Mr. Hanbury Tennyson. He had fishing rights, and the court decided he couldn't claim adverse possession because, you've got to possess the actual soil, if you like, and not just have fishing rights. That's not enough. So that was it, the Mr. Robertson going around Wales.
Thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.